everyone, today we will do legal dictation exercise number 10. You can get the PDF from description box. So ready? Start. The appellants filed an appeal aggrieved by the refusal to refer the matter to a handwriting expert, contending that they had obtained a preliminary report dated 4/2/2007 from a handwriting expert with reference to a photocopy of a agreement receipt that the handwriting expert could give expert evidence on the genuineness of the document only if he got an opportunity to examine the original also. The said appeal was disposed of by a division bench of the High Court on 1/11/2007 with the following observation. In our considered opinion, the apprehension of the learned counsel for the appellant is misplaced and unfounded, as the appellant can file an application before the learned single judge seeking intervention of the court to permit a handwriting expert to examine the original receipt agreement to sell dated 7/9/2003, take photographs, etc., and give his opinion with regard to the genuineness of the said document. As and when any application is filed by the appellant, the same shall be considered by the learned single judge in terms of the observation made herein, giving due weightage to the submission of the learned counsel appearing for the appellant. In pursuance of it, the appellants filed an application on 7/1/2008 under Order 26, Rule 10A of the Court to permit their handwriting expert to inspect the original agreement receipt dated 7/9/2003 and take photographs thereof so that he can give a further report as also evidence. They also made another application on 7/1/2008 to modify the order dated 31/7/2007 and defer the examination under Order 10, Rule 2 of the Code till the report of the handwriting expert was received. In the meanwhile, the plaintiff Harban Lal, having died on 12/11/2007, his legal representatives came on record on 29/4/2008. On 3/10/2008, a learned single judge directed the principal officer and managing director of the first appellant company to appear in person on 12/11/2008 along with its annual returns filed with the registrar of companies, income tax returns and balance sheet for the financial year 2003-2004 onwards. In pursuance of the said order, the second appellant appeared before the court with the relevant documents on 12/11/2008. The second appellant was examined under Order 10, Rule 2 of the Code of his statement recorded by the learned single judge is extracted below. I am the managing director of Mrs. Kapil Kotax Private Limited rupees 9 lakh received from the plaintiff is shown in the statement of account of the defendant number 1 company. However, the said amount is not reflected in the annual return of the defendant number 1 company, which was filed in the registrar of companies. It is correct for the period ending 31st March 2004 receipt of share application money of rupees 9 lakh is not shown and mentioned. As on 31st March 2004, the paid up share capital of the defendant number 1 company was rupees 51 lakh. This did not include rupees 9 lakh. Defendant number 1 company is a private limited company. The plaintiff did not file up any share application form, share allotment form before payment of money. I am not aware whether a request letter or a share application form is required to be filled up by a party before shares can be allotted. At no point of time, defendant number 1 has recorded or mentioned entry of rupees 24 lakh as received from the plaintiff in cash. We know the plaintiffs. We have known them for several years.